Okay. All right. Good morning, folks. This is Commissioner Jill Carmy. We're here for the 10:30 minor guardianship docket. I see a couple folks still connecting to audio. We'll just give it a minute. Well, let's go ahead and take a matter. I think all the parties are on first. This would be number 3 on our docket, 234-00-23408. This is the guardianship of Audrey Harlan. Good morning, Mr. Anagnosto.
Good morning.
For helping for building their own home.
Okay, if you're
So it's actually through
but you're going to need to mute if you're not actively being called in a case. There's lots of background noise. Okay, let's try and recall this case. Mr. Anagnosto, I have what appears to be an agreed order terminating guardianship. I'll let you fill me in.
Sure. My client's got custody of the child several years ago. The child has been transitioning back to the mother. She's been in a Oxford type house in a facility, and she's got her other child returned to her, and so the child has been pretty much back with the mother. And so my clients no longer feel the need to be, this was pre our new guardianship law, so they had custody, but no longer want to be or need to be guardians of the child. And so they want to dismiss. We served the father, he's in jail, and the mother has consented to the dismissal and the return of her daughter to her home. And we think that's all in the best interest of everybody.
Okay. And thank you I do have the original order. Thank you for providing that to the court. Do I have parties on this matter? Sabrina can't, Jeff can't, any other parties?
You have Jeff can't, Your Honor. My wife works in the hospital and couldn't be present today, so I'm here.
Okay.
And I'm here as well, Candace Breyer, the mother.
Okay. And Candace, just checking with you that this is also your agreement. I do have the signature of Sabrina, Jeff, and the attorney. Is this your wishes as well?
Yes.
Okay. So I will, and I did see, I'll just state for purposes of the record that I did see service was made by, it appears, the Walla Walla County Sheriff on Mr. Harlan. So he did receive notice of this. I will, hearing no objection and seeing that service was made, I will grant this motion and sign it today. Is there anything else the parties need from me on this matter?
I don't think so, Your Honor.
Okay.
Thank you.
You're welcome. Thank you. And I'll
appreciate it.
this to the court. Thank you. Okay. And then let's see. Any of the attorney matters that you expect to be continuances or setovers on our remaining docket?
Yes, Your Honor. The guardianship of Daylin Birch, I'm asking for a 1-week continuance just so that I can speak to my client. I haven't been able to get a hold of her. And I did email all of the people involved in that case.
You have that one. So Ms. Winkles, it might be an error on my end. I don't have that one on my docket today.
That will probably be an error on my end then. So not a problem. I'm glad because I was asking for continuance anyway. Thank you.
Okay, so sounds like we don't need to continue that one. The one I do have you on with Mr. Gooday is Skyland, a guardianship of Skyland Stroud. Do we expect that to move forward today?
I'd ask for a 2-week continuance. I don't believe he's even spoken to his client. And I don't mind continuing that. If he's not here, I just ask for a 2-week continuance and I'll email him.
Okay. I remember he was on last week, and we did the 1-week continuance. I'll recall this at the end of the docket just to see if he pops in, but otherwise I would be inclined to issue the 2-week continuance. I did see, I think the current order expires July 22nd, so I would need to extend that to our next hearing. And I can certainly do that. So we'll wait and see what he does.
Sounds good. Thank you, Your Honor.
And then let's call in-ray guardianship of Renzi Bragg and Rex Bragg. This is number 4 on our docket. This is 234-0026-008. I'm gonna pull up our digital file. Give me just a minute. And I see this, it looks to me like this would be our first court appearance on this matter. So if the parties could introduce themselves to me, that would be helpful. Ms. Buck, are you here on that matter?
Yes, I am.
Okay. And can you give me your full name?
Christina Lee Buck.
Okay.
Can't see myself, so I don't know what's going on.
And you are the individual who filed the petition in this case, correct?
I am.
Okay. And then do I have any of the attorneys on behalf of the parents in this matter? Looks like I have a Myrna Bragg online.
That's Grandma.
Yes, Myrna Bragg's here. I'm the biological maternal grandmother.
Okay. And what's your role in appearing today?
To be in support of Christina and Thomas Buck receiving the emergency guardianship for Rex,
Okay.
Wayne Bragg, and Renzi.
Okay.
Mhm.
Then I'm just looking at our other folks online. Is there anyone else here on this matter?
My name is Sarah Williamson. I am Savannah Bragg's biological sister, the mother of the 2 children, and I'm also on here in support of Christy and Tom Buck receiving guardianship of the 2 children.
Okay. Do I have anyone on behalf of Savannah Bragg or Ray Wing? Go ahead. I see someone with a hand raised. Jacqueline Ward.
Sorry, I was just going to introduce myself as cousin of Savannah Bragg and giving support to Christina for guardianship of Rex and Ivy.
Okay.
Mom.
So here's my concern with moving forward. It looks like, so Ms. Buck, let me ask you, it looks like the service you made was done on 2 attorney or law firms. Are these folks who represent the parents in this matter that you know of, or are those attorneys for them in other matters like criminal, family law, etc.?
No, they are their attorneys for DCYF. And we made sure that they received the emails in a timely manner. So I'm not sure why they haven't shown up.
Well, I mean, I can tell you it's probably because they've had 3 days notice and 2 of those days have been a weekend. So I don't think I can find that this was timely service on them.
Okay.
So we are going to have to reset this. You are going to have to reserve. I do, because we work with really tight turnarounds here, I would like to go ahead and point a GAL with the court. Is the court okay with that, even without a fact-finding hearing? Okay. And would it be Sherry Farr? They gave me this list.
Yeah, you'll use that. Yes.
Okay. Okay, perfect. Do I put it on this spreadsheet or, okay. So what I'm gonna do, Ms. Buck, today, I do think that we need more time for you to serve the parents. And this is a new proceeding. My preference would be that the parents themselves are personally served. But certainly if you want to reissue notice to the attorneys, that's fine. But please follow up and make sure that they've received it, that they're aware. Sending them notice on a Friday of a Tuesday hearing is not legally sufficient.
Yeah, that's all the time I had to have it done once I got the court order. And then the dad is incarcerated in Clark County Jail, so I don't really have a way.
You can take the papers to the Clark County Jail and they will hand them to him.
And the mother, I know she got it on Friday because she emailed DCYF.
Okay.
And so, yeah.
So
I know I received them,
so what I'm gonna do is we will reset this. Give me a minute to fill out the rate. So I'm going to assign what's called a GAL, a guardian ad litem. Or at this stage, do you guys keep it a court visitor?
Either.
Doesn't matter. Okay.
They're different in their roles, but it's up to you whichever one you want.
Okay. Do you expect there to be objection to the guardianship from the parents?
not that I'm aware of.
Okay.
Something we were all in, like a complete alignment with.
Mm-hmm.
And I already have Rinzi in my care. So,
Okay.
yeah.
I'm just trying to decide what would be the more appropriate appointment here.
Your Honor, if I may give you
Yes.
just a little information. So this is Sherry Farr, the
Yes, thank you.
visitor. So when a court visitor is appointed, it's usually when one or the other parent cannot be served. And when there's a guardian ad litem appointed, it is because the child is there are issues with the child that need, or the guardianship that need to be investigated.
Okay. So since we would be appointing you, it sounds like we're going to work on service. And I think the issue really would be someone to advise the court on the appropriateness of the emergency guardianship and potentially ultimately a full guardianship. What would be your preference, Ms. Farr, for the type of appointment you would receive from me today on this?
From what I've heard in the hearing, I think probably starting as a court visitor would be the best avenue.
Okay, I appreciate that input. Okay, so we will appoint Ms. Farr as a court visitor effective today. I'm going to extend the immediate order, and I will get that filed after docket today. Let's go to, and so Ms. Buck, you will need to get a copy of this immediate order, which will give our next hearing date. You can get that from the clerk's office here in Cowlitz County. And Ms. Farr, knowing that you are now appointed on this case, what is your availability for the next hearing date? Knowing that I'm not expecting there to be a final report or recommendation at that time necessarily.
I would say at least to August 1st, at least 2 weeks, maybe 3.
Yeah, that's what I was thinking. Ms. Buck, my preference probably would be to extend the emergency immediate order through August 8th, which would give us about 3 weeks. That would give you more time for actual service. And it would give Ms. Farr time to contact parties and give appropriate feedback to the court. Are Are you comfortable with that? August 8th at 10:30?
Well, I have to be. I was hoping, with the concerns of Rex, where he is now, that we could get him moved, but that's okay.
Well, and tell me what you mean by that, because my understanding is you have been appointed his emergency guardian through the ex parte order that was signed.
I am the emergency guardian for Renzi.
This order has both Rex and Renzi.
That's who I'm trying to get Rex as well.
Where is Rex?
He is with a lady that he got put there by the mother and left, and I would love him to be with his sister. And
Yeah, and we're talking about the minor child, about 18 months old. Yeah, he is contained in the emergency order that was signed by Judge Michael Evans just here on July 12th.
okay, so what does
So,
that mean exactly?
and he would be included in my extension order to August 8th. So as of July 12th, you have been named as the immediate emergency minor guardian for Renzi and Rex.
Immediate. Okay. So can I go get Rex legally?
Yes, yes.
All right. Thank you so much, Your Honor.
Thank you, Your Honor.
So I will come in and get the paperwork. Is the lady, I'm sorry, that's been appointed going to serve them, or do I need to now?
I still want you to do that. Is that correct, Ms. Farr? That's not something that we would put on your shoulders.
No, I just help you
Yeah.
with procedural efforts. I don't do the work for you.
Yeah.
Okay.
So certainly you can use Ms. Farr as a resource, but yes, especially since you know where Dad is, like I said, the jail will personally hand those papers to him. That's probably the easiest way since you know where he is. And Mom, I would recommend the email to counsel and then seeing if you can also get her personally served. Okay, so it'll be August 8th. If you want to, and Renzi and Rex, are they both currently in the state of Washington?
Yes.
Okay, so if you want to come to court, I'll have that order ready for you. Soon as we're off docket, let's say 11:30, I'll get those orders prepared into the court. So by this afternoon, those will be in the clerk's office for you.
Okay.
Okay.
And do I need those when I go to pick Rex up?
I would, in case that law enforcement has to get involved. Yes.
Okay. Perfect.
Okay. All right. So we'll set that to August 8th. I will extend the immediate order and I'll get the order appointing court visitor.
Okay. Thank you so much.
Thank you. So yeah, any of you folks who were on for the Renzi Bragg and Rex Bragg matter, you are free to log off.
Thank you, Your Honor.
Thank you. I'm going to see who we have left here. I have a couple individuals identified by iPhones, iPhone 2 and iPhone 3. Can you just unmute and tell me who you are so I know what case you're waiting on?
Hello?
Hi.
Yes.
Can you hear me?
Yes.
Yeah. Okay, wait, hold on. You're talking to each other, not me. So let me start with the phone number ending in 9465. What is your name?
Savannah Bragg.
Okay. Ms. Bragg, you are the parent in a petition that was filed. What we did just now, since you weren't online yet, was we set your matter over to August 8th at 10:30 in the morning.
Okay, thank you.
And I'm going to be reissuing the immediate emergency order for Ms. Buck to be emergency guardian through August 8th. And then we've also appointed a court visitor named Sherry Farr, who may be reaching out to you before August 8th. Okay.
Okay.
So
Okay.
just make sure when you get contact from Ms. Farr that you return calls and that sort of thing. Okay.
Yes. Yes. Absolutely.
Okay.
So I'm sorry. I just have a question. If that's okay.
Yeah.
So does Christy or Ms. Buck have guardianship right now, or just like where? How
Yeah.
is it staying the same as it is? Okay.
So on July 12th, on an ex parte basis, a Superior Court judge in this county did sign an order making her the emergency minor guardian for Renzi and Rex. Okay. And we'll when we come back on August 8th, we can have a short hearing on whether that should be made to last for a 60-day period. Okay.
Okay.
All right. Thanks. We'll see you back on August 8th. Thank you for logging in.
Thank you. Yes. Thank you.
You're
Bye.
welcome. Okay. Let me go back to identifying who we have. iPhone 2 or iPhone 3. Can you unmute and tell me your name?
I'm not sure which iPhone I am.
You are iPhone 2. So go ahead. What is your name?
Tana Hively, Hively.
And what case are you here on?
For Jalen Ludwig.
Okay. Okay. And then there's another iPhone, iPhone 3. Can you tell me your name? If you are logged into this hearing under an iPhone, please unmute and let the court know your name. You can unmute by hitting *6.
She's having trouble with her phone. Her name is Teresa Ludwig. And she's here for Jalen Ludwig.
Okay. All right. Thank you. And then Ms. Kelly, I see you there logged in. Your name does appear. So I think everyone left is for the guardianship of Jalen Sloan. So let's go ahead and call that matter. This will be number 1 on our docket. This is 224-0041208. Okay, let's do, first of all, I know this case has a long history, and then this week some additional motions came in. So I kind of just want to go through where we are procedurally. I'll let the parties know when we were here together last, we did address discovery and visitation. My understanding was that you all had started this fact-finding hearing on the emergency guardianship and it had to get continued. And then obviously, as you both know, the commissioner who started that process retired. And so here we are. It looks like at the time that the hearing on the emergency guardianship was continued, there was not a further order issued extending. It appears to me that that should have been done, but wasn't done. So we find ourselves in a position today where my plan was that we would be having this fact-finding hearing on the emergency guardianship, minor guardianship. But what I have now in front of me is the motion to dismiss filed by Mr. Anagnosto that was filed with the ex parte judges, I think yesterday or the day before, because they saw that this matter was on for a fact finding. They handed the ex parte motion to me. No one has signed it. They handed it to me to address on today's docket. And then I did also receive Ms. Winkle's motion for immediate order, ex parte, and restraining order, kind of laying forth that she had received this motion to dismiss, so was filing these documents as well. What I would like to do, and I'm going to turn it over to Ms. Winkles and Mr. Anagnosto in 30 seconds as soon as I tell you my thoughts here. My thought is, let's talk about those orders in a bit, but I do think we need to stick with our original plan, which was to have the fact-finding hearing on whether or not to appoint the emergency minor guardian first. That is what this was set for. I understand there's been some procedural oddities in this case. And I also wanted to check in with the parties because my understanding, and you both know I'm newer to this docket, but my understanding is that these evidentiary hearings should be somewhat short. And I'm not saying 5 minutes, but I am thinking more like 15 to 25 minutes. Otherwise, we're going to run out of docket time. And this, if you folks are thinking this is going to be an hour-long evidentiary hearing, this really should be, you know, special set or put on trial assignment. But my understanding for the emergency guardianships is that it is a shorter fact-finding hearing. Let me turn it over to the parties to see if we're all on the same page here.
Yes, Your Honor, if I can. So this would technically be my client's motion in that they were seeking an emergency minor guardianship. When we went to the trial, it was interesting. It wasn't just an evidentiary hearing. Commissioner Nelson consolidated my trial setting notice for a trial on the minor guardianship with the emergency that evidentiary hearing that Mr. Anagnosto asked for. So that is what the start was. It was both the emergency and the minor that we were starting the trial, and we finished one day of it. So we find ourselves here. And as I've stated in the beginning, today is a show cause hearing. Only the attorneys argue. It's an emergency. The way it's supposed to go is you do the immediate order, immediate motion for a restraining order. You get that. That is supposed to be heard within 2 days. It rarely is. It can go up to 14. You then have that show cause hearing on the emergency, and it's the attorneys arguing or pro se arguing. You're arguing off the declarations. You're arguing what's before the court, and then the court. The reason why it's not this evidentiary hearing that Mr. Anagnosto asked for, where you have testimony, is because this is very limiting. You get 60 days. You can then renew for 60 days. If there is a minor guardianship petition for full in place, it can be extended till the date of the trial, but it can't go on forever. The fact is that it's self-limiting, which is why it's a show cause and not this large trial. The trial is supposed to be held within 60 days or at a maximum of 120 days. Obviously, there are some instances, such as this case, where it's going to be pushed later. And that's what's kind of happened. Now, Commissioner Nelson was extending the immediates over and over again, but we've had a ton of show cause hearings. Really, what's happened here is we had the wrong order put in. What should have been put in is the emergency minor guardianship order. Now, if I look into Odyssey, I believe one of those was actually put in at one point.
Yes.
And that means that the emergency minor guardianship, if the emergency minor guardianship order was already put in place, that means that that was already heard. And when that comes into place, this court has the ability to extend that until the trial, which is what should happen today. So we're here to argue a visitation issue, essentially. Mr. Anagnosto's client waived any procedural complaint or objection when he continued to argue and continued to set motions for visitation. That's essentially a waiver of any procedural issue that is an interlocutory order, such as a temporary order or emergency minor guardianship order. If we were here and he argued procedure based on the minor guardianship order, based on something that came to trial or whatnot, that would be a different story, and that's appealable. This is not. There's a reason for that. It's short. It's short. There's no child support. State said that. There's just what we're looking at today. So we're here, quote unquote, on a show cause for today, But in reality, the court should have just extended that same order rather than going from an immediate order to an emergency order, to an immediate order, to an immediate order. What needs to happen today is the immediate order needs to be put back in place. We do have a trial scheduled already in this case. The trial is set for, bear with me, we're having some internet and computer issues.
Yeah, and I think it's the week of August 28.
Yeah.
Although I think this is an error. Because I was at that trial assignment. It says week of August 28, 2024.
Yeah, we were gonna bring that up. It should have been 2023.
Yeah.
And that's really where we're at. The emergency order should stay in place until that hearing. The fact is the court already ruled on it. In that we have an emergency order already in place. So the court has the ability to just extend that to trial. Now we can argue about terminating that today, but in reality, the threshold's already been met in this case to put it in, which is why no objection within 10 days to that order was ever entered. And that's where we sit today. I won't argue the visitation yet because I think we're just arguing procedure. But does the court know the CP of that order? I can't. My computer is just not.
I actually, and I might stand corrected. The last thing I actually have is the March order, which was an extension of an immediate order. That was March 23rd. So I believe what we are here for is to, I think my role is to decide whether to grant an order on emergency minor guardian or not, because I don't think that's been done yet. And that's my understanding of what we would be doing today.
Yeah, it actually looks like Your Honor is correct. They're all immediate orders. So yeah, I guess we are here on a show cause, and it should be just like the show cause in all the other minor guardianships. It's not where you're taking testimony, it's where you're arguing. And in this case, we're arguing for less than 60 days.
Right.
We're arguing for a very short amount of time. So I would be in agreement with Your Honor on that, and I'll try to keep mine brief when we're ready, but I'll, Mr. Anagnostou.
Yep. Mr. Anagnostou, go ahead. I'll hear from you.
Yes, Your Honor. That's my understanding of where we're at in this case, is that there have been several emergency orders issued, and those were continued. When the trial date got stricken, there was an order from Judge Hahn striking the trial. Counsel and I got that a couple of days before the trial. I assumed that the emergencies were going to be extended. Somebody was going to extend that. I didn't realize that they weren't extended. But as soon as the trial date got stricken is when I brought my motion to expand visitation that Your Honor heard. And part of it is based on, the record that I provided to the court of Judge Nelson's rulings that he was going to consider expanding it. And so my mistake, I thought we were still under an ex parte order. And when I realized we weren't, this is a procedural issue that before the court, the court no longer has an emergency order, and therefore my Jaylyn should be returned to my client. That's our request. It should just be as summarily done. The court doesn't have jurisdiction. He's the father. Jaylyn goes to him. If they want to continue to pursue their main guardianship, that's what I call them. I call them the emergency and the main guardianship. If they want to continue to pursue that next month, we can go to trial over the main guardianship. The standards are slightly different, if Your Honor is aware, but under the emergency guardianship, it's 11-130-225. And it's a slightly different standard. We don't have to prove, because they continue to bring up the parenting functions under RCW 2609-064. Those aren't applicable. those don't apply to the emergency guardianships. The only thing that applies is that emergency guardian is likely to prevent substantial harm to minors' health, safety, and welfare. That's one, that's A. And then B, no other person appears to have authority, ability, and the willingness. And it's our point at this time, my client has, there's no substantial harm. They're claiming, minor things with regards to Jaylyn that occurred a long time ago. Diapers and stuff. She's not in diapers anymore. My client was excluded for a long period of time because of a protection restraining order. There's a whole factual dispute back and forth. And if your honor is going to consider, going forward to today, we think it should be summarily that she just gets returned, that there's no emergency. If we're going to have a hearing today, the hearsay of the child is excluded. I got the statute for that. And then there's a lot of statements that are hearsay that if the court's going to consider the declarations, those type of things, there's hearsay. There's a lot of statements that where the party doesn't have knowledge of particular facts. It's, my client never did something with regards to Jaylyn. Well, where are the dates, times, places? What are we talking about? Did you observe it, or is this something that somebody told you? I mean, all those statements get excluded. So if we're going to have a hearing today, parties have to be under oath and state facts with regards to Jaylyn and my client. But he's the father and he has a constitutional right. I looked up Troxel because I hadn't read it in a long time since law school. It's got a great quote in that case. The liberty at issue in this case, the interest of the parents in the care, custody, and control of their children, is perhaps the oldest of the fundamental liberties interests recognized by this court. It is cardinal with us that the custody, care, and nurturing of the child resides first in the parents, whose primary function and freedom, including preparation for obligations, the state can neither supply nor hinder. So your position is you can't supply or hinder my client's parenting. He needs Jaylyn, and then if the court wants to issue an order saying you can't have Jaylyn around Michelle's son, who has a criminal background, you issue that order, and if he violates it, then yeah, we're back in court on that. He's already told you what his plan is, that he's going to be living with his grandmother. Jaylyn will be living with the grandmother down in Toledo, Oregon. Got to keep those separate from Toledo, Washington. But he does that. She goes to daycare. She's in daycare now. He finds doctors for her. He can't do that because he doesn't have her. Or if he doesn't supply those, then potentially we come back to court. But at this particular time, with the dismissal of the emergency ex parte orders, Jaylyn should be returned summarily to my client. And if they want to go forward on a guardianship case, a different standard, in either one of them, they have to show clear, cogent, and convincing evidence. And the evidence is my client's a young father, and he's doing the best he can, and that's good enough for constitutional issues. So we're asking the court summarily on the procedural issue that there's no orders, return Jaylyn to my client, if we go forward, all hearsay and those type of issues and statements of the child are not considered, and that it's got to be relevant evidence that is not objectionable.
And I understand that. And here's again, kind of what I'm getting at here. So number one, I'm denying the motion to dismiss and return the child. I think that what has happened here is a procedural error on the court's part. I don't believe that that deprives me of authority under RCW 11-130-225 to go ahead and hold what was originally scheduled as a show cause motion on the emergency guardian. That statute gives me broad authority to, on my own or on motion of someone else, to appoint an emergency guardian. So I believe I do retain that jurisdiction. I have retained that. And I do see, I think that's especially bolstered by the fact that there's the full or main guardian that's been filed and is set for trial. So I am going to deny the motion to dismiss and return summarily. We are going to move forward on the show cause for whether to put into place or not the order on emergency minor guardian. What I'm trying to be clear about, though, is that we're not going to spend 2 hours taking testimony on this. That is not what the statute contemplates on the emergency guardianship. So I want to hear from folks about what evidence or testimony you expect to put forward.
Yes, Your Honor. Again, this is a show cause hearing where only you're supposed to do it based on the record that's before you. And that is because of due process. The fact is that this is a quick hearing. Each party needs to be aware of what is going to be stated, which is why we don't need testimony here. The testimony is in the form of signed affidavits or declarations signed under penalty of perjury. That's the testimony. And I would argue, Your Honor, that I will be summarizing that testimony. Your Honor has read it. Your Honor can hear from Mr. Anagnosto and myself. No additional testimony is needed if we summarize the arguments, because no additional testimony is allowed. It is, again, due process. You get the testimony, you're allowed to respond, and you have a brief reply. We've done that. I have a motion for an immediate restraining order on, which is really giving that, Your Honor, even more jurisdiction here, because that's what starts the process anyway of doing the emergency order. So I'd ask that just the attorneys argue and summarize. And even if we only have 5 minutes, Your Honor's read it, you've heard it. We have the same issues with regards to child hearsay. The fact is the guardian ad litem is given broad powers to investigate, to speak to the child, and to give the court information about the child conducted during their investigation, including what the child's wants, needs are, and what the child has disclosed to them. It is not for the truth of the statement. It's not put forward for that reason. It's put forward for a different reason. And that is just getting the child's view of what is going on. So the child hearsay, I'm not arguing. If I were arguing it as my client heard this, fair enough. But the fact is the guardian ad litem that is in the report, that report is allowed to go to trial in all these cases. The guardian's allowed to be questioned on that, and that's what we have here. It's essentially the same as a medical statement or a report of CPS, which are always allowed in these cases. So I don't know if Your Honor wants to hear argument, and I can start on why there should be an emergency order.
Yeah, and just a minute, and we'll get there in just a minute. Mr. Anagnosto, what evidence or testimony are you asking the court to rely on? It looks like you have witnesses here, and so I just want to make sure we're all on the same page about how we're proceeding on testimony. I do note the statute does contemplate that the court can make findings from affidavit or testimony, so I'm not opposed to some testimony being given live here today. I just want to be clear that this is not our trial, and I want to be cognizant of the attorney's times, the witnesses' times, but also the court time and this docket, which is not intended to be a trial docket.
Right, and that's what happened when we started hearing on this the first time, and that was, we were only hearing the emergency guardianship petition, and I provided the court some of the transcripts from that testimony. You can go back and see the whole testimony. So I understand Your Honor is indicating that we can have limited testimony. But I want to, reiterate that the declarations that contain hearsay and the declarations that have no, factual basis for their statements are all objected to. And child hearsay is objected to. And if Your Honor wants the cite for that, that's RCW 9A 40.44.120. And it's clear. It's very clear that child hearsay is not to be considered in these cases. There's only very limited circumstances when you can be allowed.
Right, and I understand the objection. I am moving forward today on the hearing on the order for emergency minor guardianship. Are you anticipating oral argument to summarize the evidence that you would like this court to consider, or are you wanting to call your client or any other witnesses?
Well, I would call my client in rebuttal if we're going to hear testimony. He's here, he's prepared. We got witnesses that are prepared to testify on his behalf.
Right. I mean, and that's what I'm getting at. I'm not sure I'm getting a real clear answer.
I'm sorry.
No, I mean, technically, and certainly we could probably go till the noon hour, but technically this docket is over in 14 minutes. So, that's what I'm trying to get at is what are we anticipating timing wise? Are you anticipating calling your client or just reserving him for rebuttal based on what Ms. Winkles may say?
I would like to call my client. He has not had an opportunity to be heard. Ms. Winkles got through several of her witnesses when we ran out of time the first time.
Okay. Well, and that was a different scenario. And so I want the folks to be clear. I have not and don't plan to go back and listen to that because my understanding was it was a consolidated trial or fact finding on both the main petition and the emergency petition.
No, I don't think that's correct, Your Honor. It was only on the emergency.
We actually had a hearing on that, Your Honor. It's in the court minutes.
Yeah.
Dave Nelson said, I'm on the trial setting docket, so I can consolidate both of these together. You'll see that I had a trial setting notice as well, saved for that. And you'll see when the court scheduled the trial, they scheduled the trial for both of them. So that's not accurate. It was on both.
Yeah, I mean, that is my understanding. Let me just go back and make sure that is contained in the court minutes.
So this is what I recall happened. We started the emergency hearing and I requested pursuant to the court rules that it be evidentiary. We needed to have an evidentiary hearing on the emergency and that's what we started. And then it ran long and got continued. After the hearing is when Commissioner Nelson said we should combine both of these for the next hearing. It was at a subsequent hearing that we had. I don't know if I had that in.
Okay, so I am looking back at the notes from Commissioner Nelson on May 5th. It does look like you all discussed the proceedings and Mr. Anagnosto's recitation appears most in line with what the actual notes state that I think there was a discussion about doing it both for purposes of economy, but that the court stated specifically, quote, we will move forward in re emergency minor guardianship. And then testimony began at 1:37 and you guys were still going until 5 p.m.
Your Honor, if you can look at the trial setting, the minutes from the trial setting, because I did a trial setting notice and we were heard on that and rescheduled. And then we started that as well. So we've started twice now.
Yeah, and then at the end of the May 5th hearing, the court set the matter for assignment on May 17 for a continued hearing. And then that's when 1-day continued trial to the week of June 19th.
Right.
And that's when there was a trial setting for the week of June 19th. And then trial was to begin on June 21st.
Right.
And then I think that's where things kind of then fell off the rails.
It fell off the rails at that point.
Yeah.
If you look at the, oh, it's not on the notes, matter set for set trial, and that's on the court minutes from 5/17/2023. And that is at, yeah, it says court sets matter over. If you look at it, it's set to trial. It's not set to an evidentiary hearing. It's not set.
Right, I understand, but I'm looking at specifically what Commissioner Nelson ruled, which was whether he did this the right way or not, I'm not commenting on, but he did specifically state that you all were only taking testimony at that time for the emergency guardianship.
Yeah.
I'm not saying that's how we're proceeding in the future, because I want to be very clear. We're not going to spend 5 hours doing an emergency minor guardianship evidentiary hearing. That is not in the interest of justice. I don't think that's what the statute contemplates. And you all are set for an actual trial the week of August 28th on the full petition.
Okay, so that's what I wanted to make sure, because I have the trial setting notice on 5/8 and it says matter already set -RB. And that was my trial setting notice before any of that happened, to set for the full, if you'll look at it, it says it's the full minor guardianship petition. And so that's why I was confused. Maybe I was confused. I thought they were consolidated on that date. But so August 28th is for the full for sure. I just didn't want to have to set
Yes, yes. So August 28th, although I just need to reach out to court admin to have them correct the year, because they put 2024. And I know that's not what it was set for. So we'll get that amended so that you all know it's August 28th, week of August 28th, 2023, 2-day non-jury trial on the main petition. But we need to kind of regroup about what we're doing with the order on emergency minor guardian. And here is my thought, because I don't think there's agreement on how we're going to proceed in this matter, but I want to be very clear that I think it is a limited evidentiary hearing based on declarations, and I will allow parties to testify. So I will allow Jaden to testify. Ms. Farr's testimony will be relevant to the court. I'm not at this time going to take testimony from, we have 2 folks on the line, I believe, for Jaden. Here's my thought, Mr. Anagnosto. If they have testimony they want the court to consider, I'm kind of going back on my idea that we do the hearing today. Here's what I'm thinking, that that we set this to next Tuesday's minor guardianship docket, that we set over the actual hearing on the order on emergency minor guardian for 1 week, that any of the witnesses other than the parties themselves and Ms. Farr submit declarations for me to consider if they have relevant information they want me to consider. And then I'm going to sign an immediate order extending through to next Tuesday at 10:30. I do think that was the court's intent on May 5th when the evidentiary hearing was continued. They just didn't do it. So I believe I have jurisdiction to sign the immediate order through next Tuesday. And then I would ask the parties, I am going to limit testimony and argument to a 30-minute window, because that is what this docket contemplates. And I think that's what the statute contemplates. So if there is additional evidence that you don't believe could come out in oral testimony in that time frame, I want it to come to me through a declaration.
So my witnesses have already supplied declarations. So both Michelle and Teresa Ludwig. And so
That's the the ones that were filed on July 10th.
yeah, those were
Okay.
filed. Yeah.
Okay.
So they've done declarations. My concern is this bumps along again and we don't get a resolution, and that's been
Well, I mean,
contemplated by the statute.
certainly I understand that. And I think that procedurally things haven't gone well throughout this case. In looking at the history of this was like clear as mud. So I get that. What I'm trying to do is get us back on the rails starting now. So I am going to, and believe I do have jurisdiction to sign this immediate order. I want to be very clear about what I expect the hearing on the order on emergency minor guardian to be next week, so that we don't spend a half an hour just discussing what the hearing is going to look like. So today, I believe I've set those expectations so that if parties believe that there's testimony on the order on emergency minor guardian, if they believe there's testimony that's going to take longer than 30 minutes, please supply it by declaration. I will take argument from counsel. I will take testimony, for instance, Mr. Anagnosto, if Jaden wants to testify. He is a party with, as you stated, very important and considerable constitutional rights to parent his child. So I'm not going to take away his right to testify live if that's what he chooses to do so. But again, I want to be very clear that I'm not, in looking back at the court minutes, this isn't going to be a situation where we're here until 5 o'clock taking testimony. Are all the parties available next Tuesday at 10:30?
If my clients can give a thumbs up, are you available? I know that this is getting really hard with their work schedules and that.
My client's work schedule too, so.
Well, that's also why these dockets are meant to be expedited. So
Jaden, can you give me the thumbs up or not, or next Tuesday? Okay, thank you.
the only concern, let's address one last issue before I sign the immediate order. My only concern is it does include the restraining order in its kind of an original full entirety. And I think that has been changed in this case because we're talking about things like visitation. So I don't want to go backwards.
And it was, Your Honor, if Your Honor wants to just interlineate the visitation that was set last time. I believe he has daytime visitation.
Yeah, so what I'm going to do is go back to, I am going to sign the immediate order for emergency minor guardianship through next Tuesday at 10:30. But I am going to edit the restraining order sections so that it fully complies with our current visitation that Jaden is allowed with the minor. Okay, any questions about that?
The only question I have about next week, Your Honor, is if we're going to be limited to time, are we going to limit? I mean, I don't want Ms. Winkles to put her clients on and take up all the time and my client not be able to. So are we going to say they got 15 minutes and we got 15? I
think that's a great proposal. Let's adopt that as kind of the trial expectation or the fact-finding expectations. Certainly, if there's cross-examination, so one side is taking up a bunch of time from the other side, I will take that into account. It doesn't need to be hard and fast rule, but I think if both of you plan for 15 minutes, I think that will be very helpful to the parties and the court. And I think that's a great idea.
Sounds good to me.
Okay. Ms. Farr, anything you think the court needs to consider further on this?
I think you covered it all.
Okay. Are you available next Tuesday? I failed to ask.
I'll make sure I am.
Okay, I appreciate it. And then Mr. Anagnosto, just so you know, since I think your ex parte motion for fees came into me because of all the submissions,
Right.
I have put that in the ex parte box and let Judge Basher know that it's in there and they'll be reviewing that.
Okay. Yeah, when I sent this ex parte, I anticipated that it would come before you. That's why I had the return date or time would be
Okay.
later tonight. So I thought those were going to come to you, but
Okay. Yeah, it created a little bit of confusion over here, but looking at the history of this case, that seems to fit with how this case has gone anyway. So just wanted you to know your other motion is in the ex parte box and should be handled today.
okay.
Okay. All right. Thank you all. Ms. Winkles, let's go ahead and take that last case. I don't think Mr. Gooday appeared. This is guardianship of Skyland Stroud, and I think the request is for 2-week continuance.
That's correct, Your Honor.
Okay, so this will be 234-0011-308. When we were here last, I know there were some timing issues, so we bumped it over a week. At that time, I did not extend the order. We have an order appointing the emergency minor guardian. I didn't extend it because it looked like it already extended through July 22nd, but we will need to do an extension at this point. Except the question I had on this one is I don't see a full petition filed.
There's an adoption filed.
Ah, okay.
Yeah, and it's mom's rights were already terminated technically under that, but because there's no actual, even though it's terminated, doesn't mean one party gets the child. So it's just, it's safer for my clients to have the guardianship.
Okay. So if we extend May, June, July, I'm still within that second 60-day window, it looks like. So I think what I'll do is I'll set this out 2 weeks.
Okay.
But my extension order is going to cover, let me get to the first order. The first order was April 11. So let's say the first 60 days was approximately June 11. I'll do the exact calculation. And then June to July and then to August, which I guess gets us pretty close to our next review date. So maybe I'll just do it through the second review date.
And to be honest with you, the adoption may have gone through then.
Okay. Okay. So 2 weeks out is
the first.
Oh man, it's already August in 2 weeks. Okay. So this one I'll extend through August 1st to our next review date. And then if you let Mr. Gooday know, Ms. Winkles, that would be greatly appreciated.
I'll email.
Okay.
Thank you.
All right. Thank you all. All right. We